My name is Paul Gulbenkian, and I'm a consultant solicitor with OTS Solicitors in London. In 1964, when I qualified as a solicitor, at that time I was doing mainly litigation and matrimonial work, but being of Armenian origin, Armenian clients came to me from various parts of the Middle East where they were facing problems and fleeing. And they came because I spoke the Armenian language, and I could then help them with their issues, their immigration issues, and to get residence in the UK. And that's how the immigration side of my work began, and it then developed because, by recommendation, those clients gave my name to other non-Armenian, shall we say, clients who wanted immigration advice, and it sort of grew from there. The immigration rules, practices, procedures were really very straightforward. I used to see the client in my office. My office was in High Holborn. Fortuitously, the Home Office was also based in High Holborn, almost opposite where I worked. I used to see the client, get his instructions or her instructions, go across the road, speak to an officer there across a desk, explain the situation, what they wanted to do here, and more often than not, they were entirely happy with whatever I explained to them. The client handed over the passport, it was stamped there, and they were given their residence. So it was really very simple. But as time went on, so it became more difficult and more complex. In 1971, the Immigration Act was passed, which involved much more work, and much more legislation flowed from that, plus immigration rules, and the work therefore became much more difficult to deal with. I've also had to deal with cases where there was discretion being sought outside the immigration rules. For example, some people who had particularly compassionate or exceptional circumstances didn't quite come under any of the rules that had now been set out quite clearly in the immigration legislation, and they nevertheless wanted to stay here or come here. And I used to seek the exercise of the Home Office's discretion, which I still do. I mean, it's still available to clients to get their cases dealt with in the discretion of the Home Office outside the rules. So that increased the workload of myself and other immigration solicitors. And then in 1998, the Human Rights Act was passed, which brought into UK law the European Convention on Human Rights. That convention has a number of articles. For example, Article 8, which gives the right to respect for private and family life in the UK. Quite a few clients who perhaps didn't come under any of the rules or any of the policies sought to stay here because if they were removed from this country, there would be a breach of their human rights. So there were applications that I made under human rights grounds, which again made it more interesting, but also a more complex and difficult area of law to deal with. And then to move on to the present, really, to more recent events, what I call the Brexit referendum happened. The result of that was that European nationals became afraid and worried about their status. They came to people like myself to get some form of regularization of their status, to get some document to show they had the right to stay here, and that increased the workload that I had to deal with, and is still ongoing as of now. The negotiations to deal with this, among many issues in relation to our coming out of Europe, are being discussed and negotiated. So the work carries on, and clients from that part of the world are also still seeking assistance and advice.